what does it look like when you're trying to figure out, all right, well, how do we prioritize these cases? What am I pushing? What am I not pushing? What are you doing from the business side?
So we employ a system where we're always trying to get it a new jury trial a month, and sometimes 2 a month, right? A little bit spaced out, and something like 90% settled. They start to get more reasonable near the end. But that's our process. We think it's the time on desk, which is the moment they sign to the final disbursement, as an assembly line. Everyone's adding value in between.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back. And today we've got my good friend, Beau Correll out of Winchester, Virginia. Beau is a good friend. He and I have been in touch for the last couple of years. He's not only a personal injury trial lawyer, but he's also a former criminal defense lawyer. So he's seen the courtroom, Beau, and criminal prosecutor, right? So he's seen the courtroom from all sides. Really excited to have you. One thing I want to mention about Beau before I turn it over to him for him to introduce himself is that Beau is a constant learner. I've been to a handful of conferences, and Beau's been to those same conferences. In fact, it's very likely that if you're going to one of the conferences that you need to be at or one of the training seminars, Beau and his team will be there. So, Beau, thank you for joining us. Looking forward to our conversation today. Before we get started, go ahead and introduce yourself.
Yeah, same here. It's a real honor to be here. Thanks so much for the invitation. And I do want to say this, Sharif is such a constant learner, and it's great running into him at these conferences. To be honest, like, it should be more Virginia lawyers, but it's usually like, these are like outside of Virginia, but it's usually Sharif, maybe 1 or 2 others. So it's great to see him also being a constant learner as well. My name is Beau Correll. I'm the founder and CEO of Correll Law Firm, a plaintiffs' personal injury law firm located in Winchester, Virginia. We cover the entire Shenandoah Valley from Harrisonburg and Rockingham County up north to the West Virginia line on 81, and then all the way east as far as Northern Virginia. But our focus is the Shenandoah Valley. And again, it's a real honor to be here.
Now, Beau, you started off, though, doing criminal work. Is that right? Mm-hmm. Tell us a little bit about that.
Yeah. So, I graduated law school way too long ago. And I said to myself, if I want to get good at this, if I want to get a baseline, understanding of not only criminal law, but most importantly, trial work, I've got to go where the jobs are. So I was a prosecutor in Southside Virginia, a place called Martinsville. That's where I learned to really be a trial lawyer. And from there, I started I came back up to Winchester, where I always intended to open up my business. This is where I'm from. I'm from Frederick County. My firm is in the city of Winchester when I started at the time, and started doing court-appointed work. And, that's how I really started on the criminal defense side. I don't do criminal defense anymore, but it was my first case was Judge Prosser. He said, "You're going to represent this individual," and I'm like, "Okay, cool. Let's do this." And what's the charge? It was setting his allegedly setting a family member on fire. And so that was like literally the first criminal defense case I had. And from then on, it's been, interesting stories to say the least. And, right now I'm persistently personal injury.
You can't make that stuff up, right? You just can't.
No, every week of doing court appointed work, it's a real adventure. You're helping people, against the government. And I've always liked to have the challenges out there that I would take on, and doing court appointed work the first few years of my practice was certainly that.
What was it that said, hey, it's time to shift gears and open up a personal injury practice?
Well, it's interesting. I was first inspired a little bit by a buddy who I met working for a political campaign in '08. His name's Joe Higuera. He's one of the top personal injury attorneys in San Diego. And, we saw eye to eye, about the world. And he invited me to come on out and hang out. I went out to San Diego. I'm like, wow, this is really another level. I've always loved business, and it really combined both of those together. And I was, he inspired me quite a bit. And then it sort of evolved locally to go into personal injury. The first personal injury case I had was I've always been an outside the box thinker, and it came into play on this case. This guy calls me and says, "Do you do hit and runs?" And I'm like, thinking, yeah, of course, this is something, I potentially represent someone like this. They came in and it was their kid that got hit by a hit and run. And, it was, I saw the law from a different perspective, and I really thought I'd be good at it. And the case kind of ended with the insurer tendering, but then with the counsel's permission, I'm like, this is not enough. I meet the defendant in the mall with counsel permission. And I said, I got to have more money here. And the guy brought $6,000 or like $4,000 or $5,000. I'm like, that's not enough. And the guy, I'm like, you're going to have to get some more money. And so he goes to ATM, gets more money. And I'm like, okay, I kind of like this. This is fun. So I even got more money for the client, and everyone was happy about it. And that kind of led me to it. My first personal injury trial, I'll never forget this. I defended a guy accused of putting his penis on a coworker at work, and I went to trial on that. And I'm like, first I was crazy that he just takes his penis out, puts it on the guy at work. We go to trial. I'm defending the guy, not guilty. And I was really, I didn't think it was fair how my guy got maligned that way. And we sued the guy, and we got a good jury verdict on the defamation, malicious prosecution, and maybe abusive process. I don't know what all three claims were, but, me getting into it, I'm like, I'm an outside the box thinker, and this is for me. And so, from those first couple of one-off cases, I went into personal injury, and, those sort of rare cases that don't happen much anymore, but they were my first couple of brand new cases that I was, I encountered as a personal injury attorney.
It's awesome. It is amazing, how much creativity goes into this type of work, and how you can find different angles, right? And also just kind of the different types of cases. I mean, I explain to people, we do everything from, right, your car wrecks to your products liability to your sex assault to all types of stuff. So whenever someone is hurt at no fault of their own, give us a call, right? We're happy to at least look into it. Yeah.
I mean, and it's always about finding new angles and pressure points on the insurers, right? So, not every case is the same, and there's frequently claims you got to explore. There's some common law claims as well. They're not abrogated by statute, and it's mentally challenging. I like that part of it too.
Tell me a little bit more about pressure on the insurers.
Yeah, at Correll Law Firm, we're real big on keeping the insurers on their heels as much as possible. The defense mantra is delay, defend, deny, or deny, delay, defend, something like that. And we're the opposite. So we are, for example, I don't mess around. We'll do a demand. We'll give you all the information you need. You get 15 days to make a decision. And if you're not even in the range of reasonability, it's on, and that deal is off the table. And we go immediately to suit. We try to depose the defendant within 60 days. especially the individual defendants, right? We don't care about the discovery when it comes to individual defendant. Corporate defendant, you're going to have to do a lot more homework. But when it comes to individual defendants, some of the things you might want to do is just go straight to deposition, so they can't manufacture defenses out of thin air. We'll move to strike affirmative defenses immediately. Once we get their BS answers, we're going straight to attempts to confer. We have a policy here at the firm that for every case in litigation, there must be a significant step forward every month. And so we hold that on myself and everyone at the team here, and the team does a really great job at it. So we just keep the pressure on, keep going to make it, a real grind for the insurer too, because we negotiate a little bit differently too at Correll Law Firm. We want to get the most that we can for our client in the form of compensation, but we also want to be reasonable, at least starting off. And so it kind of reminds me of the Denzel Washington movie, The Equalizer. You ever seen that?
I'm sure I have. I don't remember it though.
It's a great movie, but basically the way this guy starts off is he always gives a reasonable out to people at the very beginning. And then when they say no, or they want to, be unjust, then he takes it to the next level, and then to the next level and the next level. And that's what we want to do. We always want to keep pressure on the defendant, and we always want to give them a reasonable out at the very beginning. We'll make a demand that's high but reasonable. And then, one of the ways we keep them on their heels is we unless there's a material development in the case, we'll never go back to those good numbers. Those more reasonable numbers at the beginning of the case. So that's kind of how we keep the pressure on them.
Have you all noticed that once you start dealing with the same adjuster over and over again, they know what to expect when it comes to dealing with your firm?
Yeah, we have noticed some of that, but we don't let the identity of the adjuster dictate what we're willing to do. It will dictate or inform upon resolution, but also some adjusters are just going to be really unreasonable. And when they say something like, well, let's just see what the defense doctor says. I think to myself, well, first off, you should have done this internally, first of all. And second off, they're not going to be reasonable. They're going to have, a lot of times quacky, messed up opinions. And if you're using that, an expert that spends their whole career having unreasonable positions you're going to use them to inform upon the strength of defense's case. It's just better to proceed if they didn't do it, or didn't say, well, we got to see an expert. But when it comes to the adjusters, we kind of treat them all the same, respectfully. We're polite. We're very polite, but then sometimes we're just incredibly direct. And, we're not big on extensions just because, for example. Oh, and another thing we like to do is try to get a trial date as quickly as possible. I mean, we're trying to do that within 60 days. I'd try to do it within 30 if we could, but you normally can't do it that soon.
Have you ever run into the situation where a defense counsel won't agree to set a trial date until a certain amount of time has passed? For example, I've run into a situation where defense counsel will say, oh, we're not willing to agree to a trial date until written discovery is done or until a deposition is done. I'm not a fan of that, and I don't think there's any rule that permits that. But just curious if you've ever run into that situation.
I would not. You're more patient than me, because I would say, why don't you just tell it to the judge? Why don't you say, my guy can't get his day in court because your company takes too long to process medical records? I mean, it's just, I'm very polite, very respectful, but that to me is gamesmanship. It literally can take, depending on the severity of injury, but it could take a week to get the gist of what's going on, and through their computer systems, they'll be able to extract all the diagnosis codes. I mean, they know it. So it's just like the more time is not our friend, right? And so I try to nail down trial dates immediately, because that's the one thing where they know it is their deadline. Where, everyone could agree to deadlines. That's the real deadline, right? And the dates that approach that. And so the sooner I could get those dates, the better. But I have had defense counsel say, "Well, it's we need more time. I'm like, "You don't have any more time. We're going to go tell the judge, and we're going to get our trial date." And same goes for defense depositions, individual defendant depositions. They'll say, "Well, I need more time." I mean, brother, it's month one. You've already written your discovery responses. Let's do this deposition. And there's always some mistake, but also there's a lot of dynamics that change where, like, someone's not available, they move. So I'm trying to encapsulate those stories as quickly as possible.
Yeah, and your time moves fast, right? So like, a trial that's 9-12 months from now is really around the corner, considering all the things that have to be done beforehand. So yeah, I'm not a fan of the delay either, and I don't think I really appreciated how much it happens and how it can be kind of a defense tool / tactic until I got into this line of work. We just settled a fairly significant case, and the defense moved to continue it, I think, 3 times. And it just, we opposed, I think, 2 of the 3, but ultimately the court let them continue it. But it's just, it really, really is, as you mentioned, isn't good for us for many reasons. One, our client's will to continue degrades, evidence is harder to find, and just it wears on you, right? And so I'm a big fan of what you guys are doing. That makes a lot of sense, and we're trying to do the same. But we've also actually, this is probably a good segue to something I really wanted to chat with you about, is just the business side of it. I'm by no means great when it comes to business, which is why I really like the role that I have here. But there is something about just having too much on your plate, right? You can't have 4 jury trials in a month, right? You're not going to do a good job preparing for it or even planning the appropriate time to prepare for that trial, even if 2 of them settle, right? So what does it look like when you're trying to figure out, all right, well, how do we prioritize these cases? What am I pushing? What am I not pushing? What are you doing from the business side?
Well, we're always pushing into trial, but we're also spacing them out too. So we employ a system where we're always trying to get a new jury trial a month, and sometimes 2 a month, right? A little bit spaced out, and something like 90% settle. So that they start to get more reasonable near the end. But that's our process, and we think of the time on desk, which is the moment they sign to the final disbursement, as an assembly line, which everyone's adding value in between. So when we are prioritizing trial dates, we certainly want the higher value, bigger policy cases to take priority on those months, right? And then, the staff will split up responsibilities as we get on closer to those dates. So, that's kind of how we set it up. But the bigger the case is, obviously, the more we want to have that month set up aside just for that case, right? And then we'll do GDC cases too, on a month, but those really don't take much prep.
How is it from your perspective? I mean, not only just running the business, but also trying the cases and working the cases up. How do you do it?
Sure. Well, we have systematized so much of what we do. Like, there's certain questions. Well, there's certain questions we always ask. So, like, we can consider like a parabola. So at the very beginning of the case, there's an extreme amount of work. There's an extreme amount of investigation. And then that tapers off a little bit. And, we already know what kind of experts we need. We need, what kind of medical care is the type of medical care they should be seeking, right? And we then move along, and the work gets a little less. But then we have processes where staff ask all kinds of questions, everything from, in our standard intake, for example, is we ask the Rivermead test for TBI or concussion, and then radiculopathy type questions, right? So we're trying to, at the beginning, we know the problems at the end. And so we're trying to make certain we have it all figured out at the beginning, get people to the right experts or care or whatever it is. And then near the end, we have staff have, for example, the automatic attempts to confer, for example. We know we're going to get BS objections, and all these is with attorney oversight, right? But we know what we're going to, the game plan by now. We know all the stuff they're going to try. And near the end, then, it's all prep. So, we think things get pretty intense probably 4 months prior. So we have some rules that, by 5 months prior, we figure out what experts we need. 4 months, they've been selected, and they're designated 3 months prior, according to the uniform pretrial scheduling order. And then we're just marching to trial. And we do have the kind of mindset that each case we're going to file suit on, we're intending to take it to trial, right? It's absent a material difference or, client ambivalence that arises later. We're taking them all to trial. But sometimes they start to be more reasonable at the end when they know something big might hit them.
Yeah, when that time, because the one thing, right, they can't control is what a jury is going to do, right? So, and so that you're right. That's an X factor. It's an X factor just as much for us as for them. But sometimes it's better to go with the X factor than you're not going to get something reasonable to start with, right? So it's an unknown versus something that may not be a reasonable outcome for your client. So, it's almost like they have to, if they're not getting into that soft spot, or the sweet spot's probably the better way to phrase it, right? If they're not making an offer that makes you and the client really like stop and think, then it actually ends up being really easy for us. Because if it's a no offer case, or if it's just such a low offer, then it really isn't a hard decision for the client. It's when that number starts getting close is when I think it's when it becomes a really hard decision about whether to go forward.
Yeah, I had a jury 2 days jury trial scheduled like 2 months ago, something like that. And the offer, they ran into the back of our car. It was videoed by a police officer, and they denied liability. And I'm like, really? And it was a zero offer. And I said, okay, let's do this. And they make a reasonable offer. I'm like, no, that's not how that works. They always do that. Make a reasonable offer. Buddy, if you want, nothing's preventing you from making an offer to resolve this. So that's on you. And so we just keep marching on. The offer got much, much more appetizing right before the trial. And you're right. If they're going to continue on with like low ball offers, there's really, it's better to take the X factor of a jury.
Absolutely. And it's also good for the defense bar, the insurance companies, to know that you mean what you say, right? You and your firm are willing to go the distance and can be expected to, because that reputation, I believe, is incredibly important. And I think it's something that you and I have heard over and over again when we go to these conferences, when we hear the Rowleys of the world and the Mitnicks of the world speaking, because they admit that, you're going to lose some cases, but in the grand scheme of things, being willing to go the distance, you're ultimately going to get a better result for your clients.
Yeah, I've heard that too. I think it's just a reputational aspect that we've all embodied and we accept. But I'd love to know how they do that. So I wonder, and of course they have listservs, but I wonder if they have how they do it amongst the different insurers, or does each insurer have their own database? Some do, I know, some don't. So it's really interesting. I think it's probably like how they handle Colossus, where they, the system that evaluates demands.
Yeah, I couldn't imagine that they don't track it. I think they'd be dumb not to, right? I mean, they have
I just
to
wonder
track
how
it.
they do it. I don't know.
Yeah, maybe they rely in some respect on like the defense attorney's report. I'm sure that's a factor that they consider. And I'm sure defense firms know the plaintiff's attorneys who, when they say they're willing to try the case, they are, and those who will put it into suit, but really are looking for just a settlement, right? So it has to make a difference. Well, Beau, let's talk a little bit about the different trainings that you go to. And before we go into the actual specific ones, one thing I really want to point out, and I want you to talk about if you're willing, is you never go alone. Like, you bring your team, and that's really cool. You don't just bring like one person. Like I remember, what was it, at Pilma? You had 2 or 3 team members with you, which is just really impressive. What's the reasoning behind doing that?
Well, I'm not a fan of job hoppers, right? Being a small firm, when we are serious about our team members, we want to invest in them, right? And we want this to be not just a job between jobs. We want this to be a career. I want people to grow, not just be taken care of financially, but everyone's got to have some degree of some calling that makes them happy. And if it's us and we're working together, I want them to feel fulfilled, right? So I'm a big investor in education for our team. And frankly, that's in our evaluations, our quarterly evaluations. Like, what interest have you shown in bettering your own education? Because I'll, provide opportunities, but that's also important because we want to make certain people are learning, people are growing. Sometimes people have interest in a particular area of law, and I might send them to a conference, but I'm pretty big on that because a good team catches things for each other. And sometimes, there's a hope that they might go to a conference, pick something up, and it works out. And they've learned something that now adds a lot of value to cases. But the conference I've been to, for years I've gone to, since I've been doing PI, I've mainly been going to conferences outside of Virginia. I love my fellow Virginia attorneys, and I just wish that we were more interested in the bigger aspects of law, not just, how, what's this new rule update? What did the General Assembly say last session, right? Those are important to know, especially at VTLA conferences. Those are amazing. I encourage everyone to join VTLA if they're plaintiffs' attorneys in Virginia. But these conferences I've been to 3 years of Dordick Trial College down in Cabo. I've been to TLU a couple of times, been to TBI Med Legal and others. One of our team members went to a trucking conference in, I think it was Chicago a few months ago. We're just really big on bringing our A game, and this and learning from people that are respectable in the industry really does it. Plus, I've always been the type of learner where I have to sit and watch. Sure, I read, but to see and ask questions and interact, that's a lot better for me personally.
Well, it forces you, right? I mean, if you're there, you're immersed. I mean, granted, the phone's in the pocket, the laptop's in your bag, so it's tempting. But when you're in that environment, it's so much easier to be present and to really pay attention versus just being remote learning or watching it on a screen. And then, of course, the networking stuff is also great too. And when I say networking, It's not just meeting people for purposes of business. I found just the spirit among plaintiffs attorneys is a good one. It's fun. It's nice to be able to have conversations and relate with people around the country who are dealing with the exact same struggles that we're dealing with here in Virginia. And so
Yeah.
you almost feel like you're kind of not alone, right?
Yeah.
You're part of this tribe.
The networking is amazing. And you're just always picking up new techniques. Now, sometimes you go to these California conferences, and for some reason, it appears to be these California attorneys are really on the tip of the spear when it comes to education and nuclear verdict education and all this other stuff. But yeah, I wish our fellow members of the bar really got more interested in outside of Virginia conferences, because there's a lot of gems there.
Absolutely. Well, we see there are people who I see make the trip. So in Virginia, we still got some great lawyers and lots to learn and lots to do. What does kind of really strike me is
Outstanding
that
attorneys.
absolutely is that we're an old school state when it comes to kind of our law and the way we do things. Yet we're like 2 hours from, at least Richmond's 2 hours from DC, which it doesn't make sense to me, right? I mean, we're one of 4 states in the country that have contributory negligence, pure contrib, meaning 1% you're done. We're one of the few states in the country where we actually have to state our number in a complaint, for example, or the amount that we sue for. Whereas most other places, you just state that it certifies that it's in the appropriate court, right? So it is interesting how, despite us, Virginia being a fairly modern state, we are kind of stuck in some old ways when it comes to our civil legal system.
We are, and we're also consider ourselves Virginia attorneys very, austere, and we hold ourselves a certain way that I don't think you really see with California attorneys, for example. We take ourselves very seriously, right? And so that's why there was a huge consensus against, even though it was ethical, billboards. So for many years in Virginia, you never saw a lawyer billboard ever. And now, at least on the plaintiffs bar, you're starting to see plaintiffs lawyer billboards, but they're in every other state, which is crazy. I was down in Louisiana, and it was like literally every other block there was a lawyer billboard. But that is more of a recent thing for Virginia attorneys. Now they're pretty prolific now in your part of the state, but it wasn't that way. And we always held ourselves kind of like, well, you should come to us. There's no direct marketing or anything along those lines, but we are evolving, and there's a lot of opportunity there.
It's funny you say that. I remember in Vegas, what was I there for? I think it was TLU this last fall, which is Trial Lawyers University, great program, always has amazing speakers. Dan Ambrose does a great job.
Let me plug TLU a little bit with Sharif. This is if you can go to a TLU conference, like a 2-day conference or so, you should go if you're interested in trial work, plaintiff's work, because they're so dense on knowledge that it may be one of the best in the country, because each of those speakers are subject matter experts, from spines to nuclear verdicts to whatever. If you get a chance to go to TLU, and it seems like Sharif, you've probably been to a couple of those, I think.
I have.
Please go. It's amazing.
Yeah. I mean, because you can't see everything. There's just so much, right? And you have I think the last one I went to had 8 or 9 different tracks, and a track means a whole room with a full agenda for every hour of the conference. And so I'm not good at math, but multiply that by however many sessions there are. It's incredible. And you had guys there like Nick Rowley, Sean Claggett, Satch Oliver, the guys from Panache, Ravapudi. I mean, just incredible attorneys. So yeah, I agree with you. Now, the one thing that we're going to here next month, which I know you've been to more than once, is Lanier. And I've heard nothing but incredible things.
Yeah, I've been to Lanier Trial College, or Lanier Trial Academy. Is that it?
I think that's it.
I've been twice, and this guy speaks he's also a preacher, so he can he can preach. He can speak for a long time. So he's on stage. There's no other guests, no other presenters, and it's like 2 or 3 days. I think it's at least 2. Is it 3? Though?
We're scheduled for 2.5 days.
There you go. Round up 3 days, and the techniques are great. I've used the techniques many times, and he's the only known current billionaire trial attorney. So,
oh yeah, that guy's incredible. In fact, his opening statement in Johnson & Johnson, which is on YouTube, is one that I reference all the time. Just the way that he set up the case and how he framed it and all that. Just really exceptional.
Yeah, no, he's great. I literally had all the same notes the first time as almost the second time. He changed a little bit, but it's worth it. You're going to have a great time there.
We're excited. The one thing that I've told you that definitely want to put on your list when you have the time, and you've got a young kid now, so time is quickly running away from you, but it's that Jerry Spence method. I mean, it's a great program, completely different, right, from everything else we've talked about. And a 3-week program is by no means a small commitment, but it's a great group to be a part of. So we'll get you out there one day.
Yeah, one day. I had a really tough night last night with my little one. She's now 6 months, and she was going through teething. And so as a first-time parent, I didn't look up teething. Maybe I should have looked at some Dr. Spock more. I read some books, but I thought it was like they just need something to like put in their mouth, but it's like a full-on like scary experience. And I'm like, do we need to take this child to the hospital? Do we need to take her to the hospital? And she's like, 97% chance. No, I think we're fine. I'm like, this was really painful, awful for her. I just felt bad for her.
Yeah. And no sleep for you, right? So
no, it's all right.
No,
that's why they've been caffeine, my man.
That's right. No, caffeine is a good drug. Well, let's talk a little bit about trial. Do you have like a part that you think is most important? And we ask this of most people who join the podcast, and I probably already know your answer, but I always like asking.
Sure. For me, it's voir dire.
Tell us why.
Because if you don't succeed, you won't even get a receptive jury. It's over. Right. And I'm a big proponent on investing a lot of time in voir dire. I mean,
how do your courts handle voir dire in Winchester?
I just start doing it. I mean, I do the mini opening, and then, I give talk about bias and how we're not talking about racial bias. We're talking about just preferring one thing over the other, and sort of soften up the jury. We've had a few instances where the judge would start saying, well, just despite all that, I mean, you could still be fair, right? And the moment that judge does that, and I'll do a pre-trial memo, but the moment the judge does it, I ask to approach, and I just tell the judge, Your Honor, sir, you can't be doing that. You can't rehabilitate the juror, the potential juror. And I have a case there. I'll show it to the judge, and normally that gives me more freedom.
Are they receptive?
Yeah, no. I mean, that's the law. Now, I've had some instances where a judge does not read any of the pre-trial filings, which is very concerning. But generally, I mean, they'll follow the law, and some know it, and some know that's how we roll. We're going in there first to I'm trying to knock out every juror I can for cause. And so I think one of the jury trials I had recently, which is big for me, but not probably big for the United States, but I was able to knock off 10 potential jurors for cause. And it's fun because you have to, at least the way I do it is it's in a way where we try to point them out basically without pointing them out and inflaming the jury and making them upset, that that we've singled these people out. But no, I think it's that. I think it's obviously the opening, and it's also about who's the nicest. I'm a big believer in whoever's the nicest person has a better chance of winning.
Nicest in what respects? Like in terms of clients or the lawyers?
I grew up in the South. I say yes sir, no sir. I'm generally a polite individual, and to still have that sensibility when I'm there, I think it is important, because jurors have in their mind what a lawyer, they don't like how they act, right? And it's aggressive, it's objecting to everything. And so the way we are in discovery is much different than the role we inhabit when we are at trial. So, for us, it's voir dire. What about you?
It's the same. Absolutely.
Oh, yeah?
I mean, it's voir dire. Yeah, voir dire opening statement. And talking about voir dire a little bit more, I'm familiar with kind of two main approaches. Well, three. One that doesn't work. The first one is, I call it like the interrogation method. It's right. Raise your hand if you've been in a car accident before. Right. Raise your hand if you have family member who's a police officer, all that stuff. I find that's not very effective, and that's something that traditionally has been done because it just is. And judges, in some respects, kind of just expect that's what will happen. The two schools of thought that I have, I kind of mesh, at least when I try and do voir dire, is kind of the Mitnick school of thought, and then the Rowley, right? The Rowley, the build the tribe, the Mitnick, strike for cause, right? And I mean, it's unfair to pitch those two like against each other. I'm sure they interact in many respects, right? But is there one that you tend to follow more than the other? My personality is more conducive to the Rowley approach, less Mitnick.
So I'm Mitnick by far. I have seen Rowley do mock voir dires, and it's not my style, right? I just go in there and prime them on bias, and start asking my questions. Like, who feels this way? Come on, who wants a free ticket out of here?
That's right.
So that's kind of the way I do it, and I think it's really interesting because Rowley's obviously hugely successful at that, and it never really stuck on me. I've read his books. I love his books, but
it's certainly different, right? It's this idea of building a tribe and being okay with jurors because you may be stuck with them anyways, right? So, but his personality, I think, fits that very well. And going back to the Mitnick stuff, so one of the things that I love that I think really helped me kind of understand how to phrase bias, or in Virginia, right, our word is indifference, because I believe that's the word that we use in the code section, is his cherry pie analogy, right? The pie. Do you guys use that?
Apple pie, but I model it a little differently. Talk about an apple blossom pie eating contest. And if they really thought about it, they'd be like, hold on a second. Where is that? I've never heard of that. So, I take elements from that. Sure.
It's a good one.
Stand indifferent to the calls. That's
right. I think that's the code section, right? Which, the code section also says that us as lawyers, we have the right to ask questions related to that. So whenever a judge wants to cut you off and say, hey, it's taking too long, just remember to pull up that code section. It's fairly good for lawyers who want to actively engage in voir dire. My thought process is voir dire's kind of got three goals. It's one, or
have formed an opinion and does not stand indifferent to their cause. Yeah.
There's two others, which frankly I don't remember. I'd have to pull up the code section, but I think there's four things.
Well, the other ones are like family or something like that.
That's right. Stuff that you're never going to really come up with.
Right.
But no, I mean, the goals that I always have is, one, just try and be a credible advocate and try and build some trust by actually listening to what the potential jurors have to say. Two is to figure out people who just, this isn't the right case for them, that they may be better suited for a case up the hall, right? So who may have bias or may not be indifferent to an important issue in the case. And then the last thing that I try and really focus on is framing. And I know I don't try and like persuade, but for example, if there are issues in the case that I expect will come up, and I got this straight from Mitnick, for example, like the expert witness that you're concerned about, you can get ahead of that in voir dire by priming it with a question like, hey, jurors, like, you all will get to use your common sense. The judge is going to tell you to use your common sense with evaluating credibility of the witnesses, and that includes expert witnesses. How do you all feel when it comes to evaluating credibility? Can you all do that for someone who takes a stand, raises their right hand? Can you tell if they're like calling it like it is or pushing a little bit too hard for the side that hired them? Of course, everyone's like, yeah, I can do that. I can use my common sense. And then you take it a step farther and you say, well, what if they have a bunch of like fancy abbreviations like behind their name, right? Doctor this, doctor that, went to this school. Can you do the same thing, right? Can you use your common sense to tell if they're pushing a little bit too hard for the side that hired them or whether they're calling it like it is? And of course, everyone says yes, but what have I done there? I've highlighted that there's going to be an expert witness in this case who they need to question credibility-wise. And I can hit that in opening. And then by the time I get to cross-examination of that expert witness, actually another Mitnick phrase, not an expert witness, a paid opinion witness, which is fact,
I love
right?
That.
I love that. Paid opinion witness. By the time I get to cross-examination.
I always say they claim this, they claim that.
That's right. Well, words matter. They really do, which is why accident is a terrible word. Crash is the right word. Collision's a better word. But you by doing it that way, you've now already primed your cross. So you're not sitting back and waiting for it all to happen and then you respond. You've already helped frame that expert before they've ever taken a seat in that witness stand. So this is the fun stuff that I think we talked about at the beginning, right? The creativity and the framing.
I love it. I mean, I'm 100% with you. That's the way I do it. That's the way I don't use their words. I use our words. And I like the work you've done, including, I think I know you wrote a opinion piece for Virginia Lawyers Weekly. That was great. And I think you also put in your bench brief where you discuss that too. Or you have a motion on that. And that's really, forward thinking.
Well, Beau, I'm a bit of a lunatic, so
that's great.
So I do this crazy stuff. I push the edges, but in some respects, I don't think it's crazy.
Normal lawyers get normal results.
That's fair.
So being a lunatic is a plus.
That's fair. Well, I mean, I say lunatic, what I really mean is like willing to deviate from the norm, kind of like what you're talking about, like going outside of the box. I mean, if we really have a candid conversation about a lot of our cases, like car wreck cases, I mean, they're not accidents. They're crashes, right? Like accident is when my 1-year-old goes in his diaper, right? That's an accident. When you're not paying attention on the road and you slam into someone and put that person in the hospital, that's not an accident. That's negligence. That's carelessness. That's recklessness. And it's amazing to me how we as lawyers have just come to accept some of this vocabulary as normal when it's just not. And the reason why it's an issue is when the judge introduces the case to the jury, hey guys, this is an accident case. Or when us plaintiff lawyers use those same words, we are, just by our word choice, taking away from what happened in this case. And that's a mistake when in fact you can use the right words and you can even use it as an arrow, right? Defense is up here calling it an accident. Is this what is playing on your phone, crashing into somebody an accident, or is that carelessness? Is that recklessness?
Is that the natural consequence of that kind of reckless behavior?
Exactly.
I'm
right.
100%, I'm 100% with you. I think through these courses and probably some of the education and what you and I have read, I think one of the big developments is growing up, you think that the closing statement is, man, that's where you just light it up. And you still try to do that. I mean, I have a little bit of flourish to me. I like to make a fun closing argument, but also it's really just to convince the people all in the middle, right? And to give information to arm your good jurors to have that battle in the jury room. So,
100%. I agree with you completely. And I agree with you also that the education on this, at least the textbook education on trial advocacy, is closing's everything. Everything leads to closing, right? And that couldn't be farther from the truth. I mean, the opening statement lays out your entire case. Opening statement is the story of your case. Closing statement is the story of your trial. If you can embrace exactly what you said, that the real closing argument happens in that deliberations room, and it's really our job just to be the guide and to arm the jurors with the appropriate evidence to argue that final argument in the deliberations room, then you've hit the nail on the head. I mean, it's our job to be practical and helpful during closing.
And when it comes to impressions, they always talk about in the field of psychology, primacy and recency. First impressions matter, and recency is the last encounter you had. But in this line of work, to me, it's the primacy that's most important. It's what Mitnick calls winning in the beginning. So it's your voir dire, your opening statement, and then if you get them on your side, then the facts that line up to your theory of the case, they're more likely to accept. The ones from for a non-credible opponent are more likely to be discarded or explained away. So by the time the trial starts, that's the impression that has been cemented into the minds of the jury. And so there's some give and take throughout a trial, but you gotta focus on the primacy.
Well, there's let's take that one step farther. And I'm modeling this after a guy named Herbert Stern. In addition to that, when someone's made up their mind, in order for them to change it, they have to tell themselves that their initial impression was wrong. So now you've got the ego, right? So not only have you framed the case and given it the lens from the beginning to help the jurors or everyone watching see the case the way that you need them to see it, right? If they commit to your side, good luck getting them to change their mind, right? So I agree completely, man.
And another small thing that I have learned, unfortunately, through practice is when they come in from deliberation, they don't look at you. You need to get whatever the last offer was as quickly as you can.
That's right.
They come in, they don't look at your client, you're in trouble.
Yeah. And sadly, that happens. And you know what? I expect for people like us, it'll continue to happen, right? Because
sure.
If you're willing to try cases, part of that comes with losing. And I like to tell myself, I do a better job telling others, probably not myself, that there is no such thing as a loss, right? Because
so it's a learning opportunity.
It's a learning opportunity, but not only that, it's that next case with that same defense attorney or that same adjuster or that insurance company, they'll know that you went the distance last time and would be willing to do it again, right? So, which will be a benefit to your client. It certainly is not fun in the moment when you don't get the victory that you're looking for. It's horrendous.
Yeah.
But there are just so few lawyers who are really willing to push it to the courtroom and to actually try the case. That by being willing to do that, I just have trouble calling that a loss.
Yeah, just some losses are more expensive than others.
That's fair. That's very fair. And again, as I mentioned, I'm great at giving other people that advice when they lose. I'm not too great at being kind to myself, but I'm working on it.
No, that's all right. You're always improving, and me too.
That's right. Well, Beau, this has been fun, man. I've got a few more questions for you before we wrap up. And actually, by the time this podcast comes out, which we should have released our training program that we're doing in October, that one I sent you the other day. So really excited about that. We're bringing in some national level speakers to Richmond, Virginia on October 24th. And I'm confident you and your team will probably make the trip. It's going to be a good time if you're available.
Yeah, I didn't want to mention it because you shared it with me and it was hush hush. But now that you're talking about it, I've looked at the agenda. It is amazing. Virginia needs a conference like this, and we're so happy that Sharif is putting this thing on. It will be awesome. I suspect tickets will sell out extremely fast, so you need to get yours as quickly as you listen to this.
It's called Voir dire de Verdict. It will be October 24th, welcome party the night before. It'll be in Richmond, Virginia War Memorial. And we're bringing in Joe Freed, Kenny Berger, Elizabeth Larrick, Rob Choi, Andrew Capel-Shaw, who's amazing, by the way. And actually, he was the last podcast that should be released. It was incredible. And we're going to have tons of great trial lawyers around Virginia, the Correll law firm included. So I'm super excited. But before we close up, we have a lot of young lawyers and law students who want to get in the courtroom. They want to try cases. They basically want to do what we do, right? When you sit down with them, Beau, what are you telling them to do at the beginning of their career to set themselves up so they can get in a place where they're doing the type of work that you and I do?
Sure. Some of the comfort I have in the courtroom is I could be in a situation where the judge is like yelling, and he's done this before, not necessarily at me, maybe my co-counsel or defense counsel, and they're nervous and they're, trying to get, their hands are shaking and they're trying to get, like opposing counsel. Not too long ago, I had this situation where the judge was yelling at opposing counsel and their hands were shaking and they couldn't answer and they were freezing up. And in those types of situations, and it will happen, it's, what are you comfortable with? And I was comfortable in that scenario. I was able to just get up and speak, and a lot of lawyers would freeze up, or speaking in front of jurors. Well, I got comfortable by doing, in cognitive psychology, it's exposure therapy. So I was always comfortable speaking with large groups of people. I was comfortable trying cases, and I didn't get that way just waking up one morning and being comfortable with it and being cool under those types of environments. It's because I decided I was going to go where I could be a trial lawyer, and I didn't care where I went. And so to do that, you have to sometimes put your ego aside and take jobs, positions, or opportunities outside your comfort zone. That might be public defender work. That might be court-appointed work. That might be a prosecutor in some random small city in Virginia or wherever you live. So you do that with a purpose, and that's to gain the skill set, to gain the comfort. And once you do that, many opportunities will blossom before you. And that's the bit of advice I'd give to folks hungry for those types of outcomes when it comes to the comfort level of trial, and to be able to think on your feet too. That type of trial work was instrumental, absolutely critical to that. And it's funny, I had applied to other jobs. I applied to jobs with what some would consider prestige, like big firms, etc. And I'm glad that didn't work out, because I wouldn't have seen the inside of a courtroom for years if I did that.
All really good points, Beau. I appreciate it, man. There's something about getting that experience, especially early on in your career, to kind of develop your sea legs, right? Like, there's a book that I read by Rick Friedman a while ago, and I learned this lesson the hard way because I did go the big law route at one point. But his lesson was, early in your career, trade money for experience. And I believe that wholeheartedly, right? Just go get the experience that you need. And then ultimately, if it's money that you want, if you get really good at doing something that a work like this, well, then you'll make a good living, right? But be willing to go get those experiences early on, because they can really, really help you out long term.
And I'll also add this. So you got to differentiate yourself. So any law firm or Commonwealth Attorney's Office or Public Defender's Office that you apply to, or wherever, maybe an attorney that takes court appointments, etc., you want to set yourself apart. And what I can faithfully say is, in the cases that we have hired people, even summer opportunities, et cetera, or, two of my summers, I worked on a congressional committee, and I was writing questions that members of Congress asked the witnesses, which is crazy, to do that as a law clerk in law school. But to do any of these opportunities, you got to set yourself apart. You do that by not in a pushy, obnoxious way, but make yourself available for an interview. Call and say, may I come in and speak to somebody? And be a little bit more persistent than just throwing your resume into the ether, right? And so I think all it takes, once you're through law school, is that first opportunity. So a lot of people want to go to the best law schools, and they think they're going to get the best jobs, and maybe they do, maybe they don't. But it all comes down to your first job, right? And that first job will open many opportunities to come. And if it's not your first, your second. But you're right, Sharif. You got to be willing to put the ego aside and to go for those positions. And no matter what it takes to wedge that foot into the door, because all you got to do is put that foot in the door, and then you could open the door after that.
Yeah, and then it's also fair to say that those can be some really great work, right? Public defender, prosecutor. Mm-hmm. I mean, talk about meaningful work. Gosh, it's hard to beat, right? I mean, you're dealing with incredibly important issues, someone's liberty. I mean, it's the stuff that you see on TV, right? I mean, the criminal cases are fascinating. We started this conversation with you talking about your first criminal case and I mean, just you're never going to forget it because of how memorable some of this stuff is. So, I agree.
Well, and plus, both criminal defense and personal injury, in both of them, they're real big opponents, right? And the government is a heck of an opponent. Forget it. You're mostly, trying to work something out, talking about how great your person is, and trying to mitigate, as best you can. And then we have amazing opponents. They're actually bad guys a lot of times, is the insurance companies, right? And that is a great motivation, especially if you are a competitive person. Then this area of law is something you should open yourself up to, even the criminal defense stuff, because it's not like a prosecutor. I got great experience. You were a prosecutor too, weren't you, Sharif?
I was, yeah.
Yeah. And so, but you know what? A lot of a prosecutor's job is what happened next, what happened after that. Okay. On the low level, like misdemeanor stuff. So, but you gotta be a little bit more tenacious and probably know the file a lot better being in criminal defense. So no matter what option you choose, and I'm sure there's others, right? But these are the most likely ones. No matter what option you choose, if you want to be a trial lawyer, do trial work and do whatever it takes to get in that door.
That's right. I mean, it's David v. Goliath, both of them, right? So, yeah. And you gotta, in order to do this work, you gotta put in the time, you gotta do the hard work, and you gotta be willing to put yourself out there in a meaningful way, because you certainly can't get results or the results that your clients deserve without being willing to walk into that courtroom. Well, Beau, this has been a lot of fun, man. So I'm sure you and I will talk again soon. But thanks for coming on, and we'll stay in touch. All right, man?
Yeah, buddy. And good luck on the conference. That's going to be amazing.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.